Hello, good afternoon. It's Sunday, the 26th of June, 2022. And this video is to explain my objections to the announced delay in the proclamation of the Public Procurement and Disposal of Public Property Act. That was announced by our Attorney General Reginald Amor on Wednesday, 22nd June, 2022. And my reasons for objection are as follows. The Attorney General told us that his main reason for pausing and for causing more delay was because of his concerns over a 29-page document he had received from our judiciary under the hand of the Chief Justice. And that 29-page document laid out serious issues which would arise if the Public Procurement and Disposal of Public Property Act were proclaimed. My first difficulty with that statement by the Attorney General is that the Attorney General made it clear to us, apparently reading from the Chief Justice's letter, that in fact the Chief Justice and the judiciary were making no legal opinion, they were making no legal points. The points they were seeking to make were purely administrative. Now, to my reading, administrative is supposed to mean things like the number of courtrooms, possibly the number of cases, the need for a commercial court. Well, what I want to say is that the Attorney General went on to read for us the very first point the Chief Justice made, and that concerned the AG so much, was that there was some sort of a possibility of a conflict in terms of separation of powers. Now, as far as I'm aware, that's a legal point. So you can't have it both ways. You cannot on the one hand be having an opinion that doesn't contain any legal opinion. And your first point is a constitutional point said to be about the separation of powers. So that's highly unsatisfactory. The AG's 2 points, both of which I have difficulty with. The first one was to do with the range of issues covered by the Office of Procurement Regulation. The phrase was from a wheelbarrow to an overpass, and that isn't so. There are thresholds built into the OPR rules that prevent that kind of massive oversight and swamping the organization. The second point the AG made referred to the flood of litigation that was expected that would effectively jam up the judiciary and possibly give rise to the need for a separate commercial court to hear all these matters. And again, the actual fundamental act that was passed in 2015 contains provisions to mitigate against that. In addition, the current administration, in the person of the Minister of Finance, Colin Imbert, put amendments in place after the election in September 2015. And one of the main amendments was the establishment of a procurement review board chaired by a retired judge to actually mitigate against disgruntled contractors or suppliers filing high court actions every Monday morning. That was the argument used by Minister Imbert, who is a construction practitioner and qualified in law and so on. That was the argument used by Minister Imbert to put that amendment in place. And as much as I've been an objector, I agreed with the amendment. It made sense. It's quite astonishing now to hear that we are looking at a flood of litigation coming up. And therefore, what I want to say is that we need to get sight of that 29-page missive. The Attorney General has explained that this matter is of high importance. This matter has the full support of the Prime Minister. The delay is going to be as soon as possible. The act is going to be put in place, and he wants to consult, and in fact, he wants to share the 29-page missive during that consultation. Well, I want to say share it now. There could be no good reason to sit on it. The final point I would make is that, in fact, we well know from the recent litigation with former Central Bank Governor Jawala Rambaran, that the government has the power to dismiss people who do not execute their intended wishes, and they would face the court after. That is what happened in Mr. Rambaran's case. The point I am making is that if there are public servants or state enterprises who are blocking up the procurement law, it is in the hands of the government to dismiss or discipline those people and face the courts after. The difference between this case and the Rambaran case is that in the Rambaran case, the minister didn't advance any reasons for dismissing Rambaran. So in fact, He lost the case and costs have been awarded in favor of Rembrandt. In this case, a matter of high public importance is not being executed by the public servants, whether they be state enterprise people or permanent secretaries, and therefore there are grounds for dismissal and discipline. Okay? That is the closing point I'd like to make. This is a matter of high importance, and we need to hear from everyone. I fully support the JCC president in his efforts in this regard. And of course, we'd like to hear from more colleagues. Thank you.